The Walt Disney Company keeps getting sued. This time, it's the state of California hotel workers. Let's talk about the latest in a line of litigation here on That Park Place. Hello, I am Jonas J. Campbell, an investigative reporter for That Park Place, and here with an amazing story and another in the long train of lawsuits that is coming to the Walt Disney Company is Mr. Vash Sky. Vash, what have you got for us today?
I've got a hitter for you here. This is very interesting.
I got things.
But these things might cost them a bit of money because, California laws, they're a little weird when it comes to labor laws and so forth, and they're a little bit unordinary when considering the larger landscape here. This comes to us via The Hollywood Reporter right here. Disney hit with class action lawsuit for alleged labor violations at hotels. Hotel maintenance workers claim the entertainment giant systemically underpaid them while forcing them to bring their own tools without proper compensation. We will get back to that specific point in a moment. Let's see right here. Disney has been sued for allegedly underpaying maintenance workers at its Southern California hotels near its sprawling theme park, on top of a host of other alleged violations of labor laws. The lawsuit filed in Orange County Superior Court on Thursday claims workers were forced to pay for their own tools when not being paid the required double minimum wage and correct overtime rate. The proposed class action seeks at least $1 million in back pay. Now, this is very interesting right here because if we look at the California labor laws specifically, they are really, really interesting. So if we go right here, right, and this is StraussLawyers.com, who has the laws in quotes here. When tools or equipment are required by an employer or are necessary to the performance of a job, such tools and equipment shall be provided and maintained by the employer, except that an employee whose wages are at least 2 times the minimum wage provided herein may be required to provide and maintain hand tools and equipment customarily required by the trade or craft. And this is reflected in multiple California statutes concerning a wide variety of industries. You can see this right here. dir.ca.gov says this is the same for automotive, says this is the same for farming right here. Let's see right here. Yes, when tools or equipment are required by the employer or are necessary for the performance of the job, such tools and equipment shall be provided or maintained, except that employees whose wages are at least 2 times the minimum wage may be required to provide and maintain hand tools. So what it's saying right here is, if you have an employee whose craft requires tools that they bring themselves, and you don't provide them for them, then you have to pay double the minimum wage. And apparently, in this lawsuit, they weren't actually doing that. Now, that is added to overtime right there. So the overtime rules are very interesting. Most states, if you work more than 40 hours, that's when you actually get your overtime. However, in California, it's different. You can see right here, shall not be employed more than 8 hours in a workday, and that's what gives you your overtime. So apparently, these workers right here were being paid less than the double that they were that they should have been provided by California law, and because of that, they were getting 1.5 times for overtime, and that wasn't actually being paid either. So when you add both of those up with these 100 or so workers who are actually suing the Walt Disney Company right now, you get it's going to be a premium there.
This is fascinating to me. So just if I'm understanding this correctly, this is not the general hotel staff like the maids or the janitors or things like that. This is the maintenance staff that is doing repairs like HVAC repairs and anything that wouldn't be contracted out. Well, maybe it is things that are contracted out, but according to the hours here. So they are required to bring their own tools. They are required to do a job. And because they are required to do that job and Disney isn't providing them the tools to do it, they're automatically doubled. Their wages should be automatically doubled. And also, they should be getting overtime at 8 hours every single day.
Yes. So if they work a day that exceeds 8 hours, then you qualify for overtime for the hours that are in addition. And if you are paid less than twice the minimum wage, and you're not providing hand tools to kind of make up for that, then Here you go. This is this is what's in dispute right here. So it's really interesting. I guess it's Charlie Torres who is the lead plaintiff right here, but there's also 115 current and former workers right here. Apparently, also to the lawsuit, which we have right here, alleges that when people were either fired or they were voluntarily left the company, that Disney wasn't providing them paychecks in a timely fashion. I believe there's a couple of days in which they had to be provided paychecks. They weren't doing that, and then they also weren't being paid commensurate with consistent with California law, essentially.
Well,
and
yeah,
that's what's gotten them in this hot water.
Of course, what kind of a Mickey Mouse operation are you running here comes to mind. This is Disney. They are a giant corporation. There it is. Disney is a massive company. They know the law, says Robert Zambrano, a lawyer for the proposed class, in a statement. This is the kind of thing that, well, Disney does not need right now. Well, although I don't know if Disney is always sued on this level, or if it's just that and we're hearing about it because more of these things are happening and more people are paying attention to it, or if this is just the signs that the company itself is degrading, the company itself is not doing their due diligence on a regular basis and is not paying attention the way they should to how they should run their business. This is another fascinating thing to me, because if Disney was a more traditional values company, then I have a feeling that there would be a lot more popular support, a lot more popular sentiment against Disney at this point, because they are a giant corporation. If they were, say, a Chick-fil-A or a Daily Wire and this was going on, I can't imagine being reported on favorably. Of course, these Hollywood trades, they tend towards the workers when they talk about a lot of these things. During most of the strikes, they were in support of the strikers as opposed to the giant studios, and there's something to that, I gotta say.
Right. The court of public opinion matters, obviously, and I think you're right. I think there has been this kind of as Disney has kind of challenged what the legislature in Florida and so and has used lawfare in very interesting ways, has been sued by others. I think that perception is starting to affect maybe the judiciary. And, look right here. In December, a discrimination lawsuit against Disney accusing it of systemically underpaying women cleared a major hurdle when a Los Angeles judge certified a diverse class of employees who work across the company's movie production arm, record labels, theme parks, and home distribution subsidiaries. Right.
To be clear, that diverse class was all women.
Yes. That's exactly right.
This whole thing is fascinating to me, and of course, Disney is being sued on multiple fronts, and this is something that even as all the shareholder shenanigans are going back and forth right now, the proxy fight to get on the board of the Walt Disney Company is going on. The lawsuits have not been brought up as an indication that this company is not well run. They're mostly focused on corporate governance as opposed to these individual litigious incidents here. Vash, did you have anything else you wanted to add before we start wrapping this up?
It just keeps racking up against the Walt Disney Company, and it's this. I think this was easily avoidable, but I think they're just asleep at the wheel. I think you have a lot of these executives and managers and so forth who maybe aren't necessarily familiar with these very, very specific laws as it relates to the operations of your businesses in California. As California enacts more laws, I would presume, and I was talking to Captain John D about this actually. We were both in agreement that there might be a retraining for managers looking over some of these divisions like hotel.
I would hope so, because you need to make sure this kind of thing does not happen again. Of course, they have, if they do start changing something, then there is an indication that they were doing something wrong. That being said, we want to throw this out to the audience, of course. If you've been watching this far, first of all, please like this video if you like the video, and leave us a comment. What do you think about this whole situation? Do you think that the hotel maintenance workers have a case here? And of course, if you want to follow this story, please consider subscribing to That Park Place for all the news that should be fun.
Thanks for watching That Park Place News. For more information, consider checking out www.thatparkplace.com. And don't forget to subscribe, share, like, and send this out on your favorite social media accounts.